Hello, this is Ebony Lassiter, and this is my final presentation for the Teacher in the Law. My final presentation is on the Bilingual Education Act. I chose this topic because not only is it information that is necessary for my school, it's information that is necessary for classrooms across the country, as there is a rising number of students that speak English as a second language. So we will start with some background information. The Bilingual Education Act is also known as Title VII of the Elementary and Secondary Education Amendments of 1967. The acronym used for the Bilingual Education Act is BEA, and it is important because it was the first federal legislation that recognized the unique needs of English language learners. It was introduced by a senator from Texas named Ralph Yarborough in 1967 and then approved by Lyndon B. Johnson, who was the president at the time, in 1968. The Bilingual Education Act has been amended several times. It was amended in 1974, 1978, 1984, and 1988. It was also reauthorized in 1994. The amendments were made to the act in an effort to reflect not only the ever-changing society that we live in, but also to address the changing and unique needs of the learners that are affected by this act. The purpose of the Bilingual Education Act was to provide school districts with the funds to establish unique educational programs for English language learners. And back then, they were actually referred to as students with limited English speaking abilities, which was given the acronym LESA at the time. The Bilingual Education Act also shifted perspectives on diversity and attitudes about immigrants at the time. It presented a need for change in the English-only mentality that was adopted by education in America at that time. So I'm going to talk about a few of the cases that have been founded on the Bilingual Education Act or have come about as a result of the act. The first one that I found that I was very interested in, it was the Independent School District versus the Salvatierra family, and it was filed in Rio, Texas in 1930. So this case was about a Mexican American family who had an issue with their children being placed in Hispanic only classrooms. And actually, the Texas courts agreed that segregation was necessary in order to teach Hispanic children English. The case was later overturned by Delgado versus the Bistrop Independent School District. But this case was very interesting to me because it actually came before the case Brown versus Board of Education. That's a very well-known case because people associate it as the case that ended separate but equal. But this case actually happened in 1930, and Brown versus Board of Education didn't happen until 1954. So as we can see, the fight to end segregation in education started long before the landmark case of Brown versus Board of Education. Another very significant case was Lau versus Nichols. This was a lawsuit filed in 1974 by Edward Steinman on behalf of Kenny Kimon Lau and other Chinese students in the San Francisco School District. There were almost 2,000 Chinese students attending the school, but not found to be acquiring a sufficient education. The Supreme Court ruled that this was a violation of their civil rights under Title VI, which prohibits discrimination by any program that receives federal funding. It was ruled that simply providing the same setting, teachers, and textbooks to students who do not understand English does not actually provide them with a meaningful education experience. Another significant case is the Castaneda versus Pickard case. And this case was tried on August 17th, 1978. Roy Castaneda claimed that the Raymondville Independent School District discriminated against his Mexican American children because of their ethnic makeup. Roy Castaneda felt that the school district failed to provide a sufficient bilingual education program, which he believed would have provided them with the opportunity to participate equally in their classrooms. Initially, the court system ruled in favor of the school district as they did not believe that the children's rights had been violated. Castaneda then filed an appeal, and in 1981, the United States Court of Appeals for the Fifth Circuit ruled in favor of the Castaneda family. And as a result, legislation about what constitutes a legally sufficient bilingual education program was initiated. And this brought about what was then called the Castaneda three-prong test. So all programs that were designated for language minority students had to be grounded in sound educational theory. They had to be implemented sufficiently with adequate resources, including personnel, and they had to be monitored for effectiveness in helping students overcome their language barriers. Another case is the Horn versus Flores case, and this was initiated in 1992 against the Nogales Unified School District, citing that it failed to teach students English. Miriam Flores is one of the parents involved in the case, and Thomas Horn was the superintendent of public instruction in Arizona, which is where the case's name, Horn versus Flores, comes from. The state court in Arizona ruled that the state was in violation of the Equal Educational Opportunity Act in 2000. However, in 2009, the U.S. Supreme Court overturned Arizona's federal district court's decision and actually ruled in favor of Superintendent Thomas Horn. So here I have some links to resources that I use. There were very good YouTube videos that talked about the historic background of bilingual education. There was a video that it gave in detail some more information about the Lau versus Nichols trial. And there's a website, Coloring Colorado, that gives really good information about bilingual education and the resources to help teachers and families. Here is the references for articles that I used that led me to research more in detail some of the cases. And that is the end of my presentation. Thank you.